The law matters, of course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters. Understand the law better, and you're in a better position to decide, as we usually say, to protect yourself, your family, and your business. In this case, we will say to protect yourself, your bank account, and your personal information. So as we present various information, various topics, you may be able to handle some issues yourself. Our goal, of course, is to always help you achieve the best possible results while saving time and money. As always, we want to welcome and once again thank Attorney David Bizarre from the Bizarre and Associates Law Firm in East Providence as he continues to weigh in on the various topics that we address. So today, debt collection and the new rules, 5 new rules. If you have a lot of debt, regardless of the reason, health, it was COVID, it was unemployment, whatever, and the debt goes to collection, it's challenging, it's frustrating, it's sometimes scary. If a debt collector contacts you about your debts, you may have concerns about whether or not it's legit, whether or not the debt is legitimate, what he's doing, and what you should do. So while there has always been the consumer finance and protection laws, there have been significant changes that took place at the end of November 2021. We're going to review those changes and what you need to know in response to them. Certainly, in addition to that, there are also new scammers who have found clever ways to get to you and to your information. These rules are to clarify for what the debt collectors can do and how they can communicate with you. Think about texts and emails, so we'll get to that. So David, let's start with what typically triggers a debt collector to reach out to you?
So typically it would be because you have a bill that you've fallen behind on. It could be your mortgage, a credit card bill, a medical bill, any type of debt that you owe to somebody else where the payment is due at a certain time and you haven't paid it on time. The creditor themselves may have contacted you a couple of times, and at some point in time they may have decided, and whatever their rules are, that they've sent it out to a debt collector who is now the one contacting you.
What's considered reasonable? Not 30 days out, 60, 90? I mean, does it on occasion sometimes trigger even after 30 days? Is that reasonable, or is somebody more likely to call just in-house and try to collect that way?
You would think so for a number of reasons. First of all, the creditor themselves have to pay the debt collector when they send the debt out for collection. So I have seen certain medical providers send them out fairly quickly, and I've always thought that was kind of interesting. Maybe they don't want to dedicate the personnel and time to trying to collect the money, and maybe they have a deal with whoever they use for debt collection that says, you know, one letter and it's very little cost to them. But for whatever reason, that's where I've seen it go out much quicker than perhaps a credit card company and certainly a mortgage.
And what's been considered to be fair debt collection practices? Because we had been under COVID, I guess we still are technically, there's been some leniency in terms of debt collection. And I assume that that was relative to both mortgages for some people who couldn't, never mind pay rent, couldn't pay mortgage, and then also some medical bills. Do you have a sense, I mean, I'm not asking you to quote you on this, but do you have a sense that that's still in effect, or is that easing away so that people who are now not paying their medical or mortgages are going to be turned over to debt collectors?
Well, there were certain rules for mortgages that are very specific to just that debt, mortgage debt. And even before COVID, I remember we've done shows on it when the mortgages were a big issue. They were falling behind, and they put some ways in of modifying mortgages and working those out so that they wouldn't go into foreclosure. And those rules, some of them still are in place for the ability to renegotiate or modify the terms of your mortgage so that you can stay in place. And that's what the mortgage company would generally want too. They don't want to own your home, they want to get paid. So that's very different than medical debt, credit card debt, personal loans, that type of thing, where the rules are different and there aren't as many protections in place, but there are protections on how a debt collector can go about doing their business.
Let's talk about those. There are some things that seem reasonable, some things that, and we've heard terrible stories about harassment and threats, and what's considered fair game or fair practice.
Okay, fair practice. They cannot, a debt collector, call you and tell you that you're going to be arrested, that they're going to send someone over to your house to get the money today. They can't tell you they're going to sue you if they're not going to sue you, or they can't sue you for perhaps the debt is too old, so the statute of limitations has run, so they can't really sue you, so they can't threaten to sue you in that instance. There's a certain limitation on the times they can call and the amount of times they can call, and I know you raised the changes in how they can contact you.
So the ones that we are most familiar with is someone getting a phone call, but apparently, even before these new rules have come into place, and we haven't addressed them yet, theoretically, they were supposed to be sending you something in writing. Can you explain that a little bit?
So there are rules as to how debt collectors have to proceed. Among the rules are they send you something in writing, and the document that is sent to you has to say, this is being sent by a debt collector. And if you call the company in response to the letter, there has to be an announcement on the recording, if they're recording it, first of all, that it's being recorded, and that their practice is dedicated to debt collection, so that you know what information you're giving them can be used by them to collect the debt.
We're talking about mortgages and maybe your credit card and some medical issues. Is it true that debt collectors have the same rules when applied to businesses, or is that a whole different set of rules?
Well, there's consumer
This is consumer.
Yeah, right. There's certain rules that are just for consumers because businesses are presumed to have more of an arm's length ability to transact business with a creditor, but there are rules there too.
And so if someone calls and it's during, I think it was 7 a.m. to 8 p.m. or something like that, some reasonable hour. I understand they're not allowed to call at work unless there's something that had stipulated that they're allowed to call at work. When someone calls, what is the reasonable thing for you as the consumer to do to put some, I don't know, boundaries around it? How should you behave? What should you do?
Well, first of all, you can tell them what times will allow them to call, because you're allowed to set the time frame, not them. And if you say, don't call me between 6 and 9 or whatever times you pick, then they can only call you outside of those times. They can't constantly call you. So if you speak to them, you give them information, they can't call you again and say, well, we spoke to you yesterday. There's a time frame, a 7-day period or something of that nature, where they might be able to call you once every 7 days, depending on the rules that were set in place. There's also things that they can't do, such as threaten to call your employer and tell your employer, hey, you owe money and we want you to withhold it. They have to go through the court process just like anybody else to get a judgment to be able to garnish your wages or threaten to garnish your wages, things of that nature.
I remember in just about any topic that we've discussed, Attorney David Bizarre has always said, get it in writing, document it, keep an audit trail or keep a paper trail or something. How does that apply in this situation?
Well, again, and we will talk a little bit about the social media thing, because that bothers me a little bit.
Yes.
And it's ripe for fraudulent situations
Yes.
and scams.
Yes.
But I always say when someone calls me for anything, but if it were a debt in particular, and I haven't had to deal with this, but if I did, I would say, well, thank you for calling me. Could you please send it to me in writing? And could you also send me whatever it is that you're allegedly collecting on? I'd like to see the information that says I owe you this money. So if it's a credit card bill, send me that. And send me something that authorizes you to be calling me on behalf of whoever the creditor is.
That's a good point.
Yeah. Well, I mean, you might owe debt, and maybe some scammer has, taken a shot and say, hey, you owe your American Express bill, you haven't paid it in a while. Well, who are you? Why aren't you American Express? And if you are authorized by American Express, show it to me.
So may be that it wasn't legitimate, or the amount wasn't correct, or. And we have said in this program that we're here to try to provide resources that will help people on their own. Sometimes they can't do it on their own, but sometimes they can. And the Consumer Financial Protection Agency, which is consumerfinance.gov, is available for you to even have sample letters if you don't know how to respond to something that was sent to you in writing. And also at that site, there is a complaint.consumerfinance.gov that will allow a consumer to say, there is a problem about how they did it, or even as you indicated, they called me when they said that I told them not to, or whatever. Apart from what someone can do on their own, we've often said sometimes you need a lawyer. Is saying to that caller, call my attorney, when is it a good idea, and does it once and for all put a stop to the phone calls and even the letters?
What will put a stop to the phone calls and the letters is if you file bankruptcy. So if you have gotten into a situation where the debt has just accumulated beyond your ability to do anything about it, and there's more than one creditor who's constantly calling you and harassing you, at that point in time, you probably reach the point where you need to speak to an attorney that does bankruptcy. And when you do reach that point, you could say to the collection agency, I have contacted this attorney, you may contact this attorney, I am filing bankruptcy. And that should end their calling you. And certainly, once they get notice of the filing of the bankruptcy, they can't call you anymore.
And short of them, declaring bankruptcy, which is certainly severe, hopefully not necessary, sometimes it is, if you are saying that I'm working with a credit counseling firm, or I've gone to a bank and I am working out a repayment plan or something, will that put an end to their incessant phone calls?
Well, here's the thing. What do they really want to do? They want to collect the money. So if you've put them in touch with someone who's working on your behalf that may work out a solution to the debt situation, and they contact that person or firm or agency and confirm that you are working with them, then there really is no reason for them to call you anymore, because their best chance of getting paid is through that lawyer, agency, or group that you're working with.
I guess it's good to point out that even if I were receiving a call like that and I said, please don't call me, I don't want you to do that, they can still write to me if they want to. No matter what I say to them, theoretically, they can still report that outstanding credit, or the creditor himself, I suppose, could still report that to a credit bureau, reporting bureau, which I wouldn't like, no one would like, but that's one of the options that they have. Is that considered a threat, or is that just considered a legitimate way for them to do business?
Well, if you are behind in it, normally the creditor, not the collection agency,
Yes.
has already reported, and I think they report regularly, I have a debt, it's paid regularly, it's on time, this is the amount, this is the credit limit. Those reports go out all the time from the creditor, I'm sure, because there's no other way they could get onto your credit report. So when you're behind, I'm pretty sure it's the creditor that's still reporting that to the credit bureaus.
And so we always say it's a good idea to check on your own credit anyway, just to make sure that there aren't other bad actors doing things to you that they shouldn't.
Yeah, and to make sure the information that's on there is correct.
Now, if you find that there is a bill that the debt collector wants to collect, yes, there's a bill, but the amount is in dispute, or the amount of interest is in dispute, or some facet of that. Can that stop? Can you use that information, I'm going to dispute this, as a way of preventing them from calling, or just an opportunity for you to delay it while you go check and call that creditor or whatever else you might have as a plan yourself?
So I would be requesting the information from them, and I would say, this isn't right. Could you please send me the documentation to show that I incurred this debt, the amount of the debt, the agreement on the interest rate. Send me all of those things so that I can review them. That's going to take them a little bit of time, so they certainly shouldn't be calling you until they provided you the information that you requested.
For the first time, or even, are you saying at the second, should they not even contact you initially unless they had all of that ready to go and ready to fire off to you?
Well, they can contact you initially if they've received a claim against you from a company that they do business with that sent the creditor claim to them. So if they're following up on that, sure, they can send a letter and call you. But once you've requested the information, they've got to provide that information to you.
If you tell them that you don't want them to contact you anymore, and do they have a right to say, okay, but I'm going to be sending this to court, to a lawsuit?
Yeah.
They can do that? Is that legitimate?
Sure. And here you asked the question, when do you need to contact an attorney? When you get sued, if you don't know how to answer the case, you should contact an attorney. You probably should engage the attorney to represent you, and then the attorney will make sure that you don't get defaulted, because here's what happens in, I think, a lot of collection cases. You get called, you get a letter, the creditor, collection bureau is contacting you, they're harassing you, you're ignoring them. Then one day someone knocks on your door and gives you a piece of paper, and it's a summons and a complaint saying that you've been sued. You don't really read it, you ignore it, you default. Now a judgment's entered against you. Now the attorney on behalf of the creditor and the collection bureau, whoever's referred it to the attorney, has a judgment for a certain amount of money against you, which may be in excess of what you ever owed. And they're now going to try to attach your wages, your bank account, gather whatever information about you for assets that you have so they can put liens on your assets. So ignoring it, not contacting an attorney after you've received a piece of paper in hand from a sheriff or constable that you're being sued is the worst thing you can do.
That's quite an encapsulated story. So this is probably a good time for you to explain, you referred to attached wages. What is a garnishment, and who gets to do it, and how do you deal with that?
So to go back to the thing about what a collection agency can or cannot do is they can't tell you, we're going to garnish your wages. What they can do is if they sue you and the attorney gets a judgment against you, they then have what's called a supplemental proceeding where you'll get notice that the attorney on behalf of the creditor is filing to attach your wages so that the judgment can get paid from your wages. And there are certain exemptions that you have on garnishment. There's a certain amount that you are allowed to keep to be able to eat and pay bills, some bills, have a place to live, but it's not a lot. And so if you are sued, and you have a garnishment against you and you're making a decent amount of money, the judgment's going to get paid out of that and at a pretty quick and high percentage of your weekly wage. So you don't want to end up in a default where you're fighting a garnishment rather than fighting the debt itself.
So while I earlier had mentioned that finance.gov is a way to get information, lodge a complaint, even obtain some sample letters, including I don't owe this debt. There are actually letters that speak to that. By the time someone has waited that long and is in that situation, and they shouldn't have waited that long, do they absolutely need to have a lawyer when it comes time to have already received a notice of a judgment and a garnishment? Do they absolutely have to have a lawyer? Is that a do-it-yourself?
At that point, it's late. They needed the lawyer before that. They needed the lawyer when they got sued in court in the first instance, where they received notice that you have a case being brought against you in district court for $8,000 for debt owed to whatever, Bank of America. And if you don't respond to that within the 20 days or whatever the time frame is in the summons, you'll get defaulted. And once you get defaulted, the lawyer goes to court and says, here's an affidavit of what's owed to us, and the judge will enter an order saying judgment entered in favor of the plaintiff against you, the defendant.
Good to know. Please address, if you would, the idea about what legal aid can do to help someone who really is in a fix, can't afford to have a lawyer, but could have access to I don't know, does credit counseling help in this situation with legal aid? Explain what legal aid can and can't do for some people.
There are different agencies and services where people can get access to attorneys, either through the pro bono bureau at the Rhode Island Bar Association, for example, if they qualify for it, or Rhode Island Legal Services. Massachusetts also has the same. And if you contact them and it's a type of case that they can help you with, they may be able to, before you've been sued, set you up with the right information for a credit counselor, or help you navigate through whatever the minefield of debt is that you have, and find a way out that may be short of filing for bankruptcy.
Are debt counseling services free generally, David? Or?
There are some. There are some where these are some agencies. I recall learning about this a long time ago, where they would buy your debt, so to speak, and then negotiate it out with the other creditors, so that you pay them a certain monthly fee, and they're paying a reduced amount to all your creditors. And at the end of the day, you've paid less, and they've made money on the difference between what they're paying out and what they're collecting from you.
So it's worthwhile to consider discussing something with an agency such as this, as long as they're legitimate.
Yeah, I would speak to an attorney first.
Okay.
Get some information on it. Let the attorney take a look at what your debt is, what your assets are, give you advice in what direction to go, and then follow the attorney's advice.
So as we're about to talk about what the new federal laws are, we've discussed what's going on in Rhode Island, Massachusetts. State to state, all adhere to whatever's been done federally. But we should point out, I guess, that there are times when there are other rules that apply state to state, and the state attorney's general office has that information. And if you had a complaint, I understand the state attorney general is another fine place to lodge that complaint.
There's protection both on the federal level, Federal Consumer Protection Acts and so forth, and each state has its own rules on debt and collection and that type of thing.
And apparently, talking to the state attorney general's office, it is at times beneficial, because sometimes that debt collection agency has done things improperly, and if there's an infraction or something that they had done to violate your rights, that certainly is noteworthy and works in your favor. I'm not saying that it's going to absolve you of your sin of not paying, but nevertheless, it does mitigate the circumstances.
Yeah, it can be helpful.
So now they refer to the new debt collection rules, and some of them are scary, especially as you were just alluding to the idea about social media. But first, there's an issue about what a debt collection validation notice is. Care to expound?
So in terms of the social media and stuff, there's notice that's supposed to be given that it's supposed to validate that this is a legitimate debt, it's not a scam. And I'm not a social media person. I don't have Facebook or Instagram or whatever else there is out there. I'm not going to go back to whatever it was called, MySpace, I don't know. But so it's certain rules that they have to follow to validate that they are a legitimate collection agency, and this is a legitimate debt.
And that validation notice has certain things that it must include, certain things that they say may include, but you had addressed that at the top of this segment about that it was coming from a debt collection agency, the creditor's name, the amount. I think that there are also some things that they need to say relative to your rights in handling it.
Right.
Would you care to address that?
Yeah, so the rules, it's supposed to address the federal rules as to what they're allowed to do, what your rights are. And for example, that you're allowed to request the information to verify the debt, that you're entitled to certain protections, and also how often they're allowed to contact you, and your right. This is, I think, in this area, the most important thing, your right to opt out of being contacted via this method.
And apparently another interesting element to this is that if you don't, you had mentioned sometimes people ignore it, maybe hoping that it'll go away. In fact, when the debt collection agency now sends you a notice or calls, if you don't respond, even that you're disputing it, if you don't respond, they have the right to assume that that debt amount and all is valid.
Yeah, and they put that in their letters too. You have a right to dispute it. If you don't dispute it, we're going to assume that this is valid. So dispute it. But also, one other thing, going back to the social media, they're allowed to contact you via social media. What they're not allowed to do is post it so that it's available for the world to see.
Can't be public.
Can't be published publicly.
Yes. So your LinkedIn account, your Facebook could say that they want to reach you, but can't say, David, you're in arrears for $5,000, and if you don't, I'm going to,
Right.
Do this or that.
They can't post it on your wall, if that's what that's
The
called.
wall.
Or publish it in your Instagram feed or whatever that might be. But they can send you a friend request and say, we want to contact you, please friend us so that we can collect this debt from you.
And of course, that speaks to yet another segment that we've often covered, which is be careful who you are friending and liking and following. So how often a debt collector can call is another of the 5, and I guess it's once a day they can actually do. I didn't realize that.
If they don't reach you.
If they don't reach you.
Yep.
And if it's only about one debt, it's one debt per one call. If you have multiple debts, they can call you multiple times, or multiple agencies can call you
Right.
multiple times. Doesn't seem like that gives you much peace, but it certainly sounds that the telephone calls may be one issue. Now that they can write, now that they can post and use even text messages, which is considered as a direct message, likely to be reasonable and okay. What does that say about the scam potential? We've always talked about phishing scams.
Right. That's the thing that concerns me most about the collection agency being able to text you. And you get a text, you owe money. It's just reminiscent to me of the phone calls where they tell you to go to the CVS and get gift cards to pay your electric bill.
Yes.
What could they put into the text message? Please respond to this text message with your credit card information to pay this debt.
What's scary is they're saying that they, as of this show anyway, they are not sure about how you can follow up to opt out of it, or how you could even necessarily verify that that number is legitimate. You may not have the resources or the tech savvy to do it, which is a scary thing,
Right.
of course. What are the other things we need to discuss here? That validation notice, I guess it's just a matter of them being able to be very clear about what they can do and
Right.
how to contact you when you need to respond. I think that was a limited content message. It was about voicemail. There's a very clear listing of how much information they should and can put on the voicemail message, and we should tell our audience too that they are at times likely to do that even if they're trying to find out about your neighbor or your family member, if not you, so to beware
Right.
about that.
That's right. And the problem with putting too much information on is they don't know who's going to listen to those messages.
Well, we hope that this has been helpful to you. We ask you that you stay tuned to The Law Matters. It certainly matters to you.